Hello, let's talk about what you should put in your bylaws, operating agreement, or a partnership agreement. We're going to talk about those different agreements in the same video because those are all different titles for the same type of legal document. It's the primary foundational contract that outlines the basic rights and obligations of business partners in a particular commercial setting, whether it's an LLC, it's a partnership, it's a international joint venture, founders agreement, shareholders agreement, all of the same principles will apply to those documents. And why would you have them in the first place, you're wondering, particularly if the company is just you're a sole member LLC or a sole shareholder in the corporation. You still need the operating agreement or the bylaws because banks will ask for it. Government entities you're dealing with will want to see it. Investors will definitely want to take a look. Pretty much anybody who needs evidence that the company is yours will ask for the operating agreement or the bylaws. And anybody who wants to see that how many members are in the company will want to take a look, because bylaws operating agreement is where the members are listed and their percentages of ownership are outlined. So now that you know that you need the bylaws or operating agreement, what do we actually put in it? Talking about members, how many classes are you going to have? Are you going to have just one voting class of members, everybody is the same? Or do you want to also have non-voting members? You want to have active versus passive investors? All of that needs to be spelled out because frequently there are disagreements down the road. Somebody thinks they were passive investors. Other members think that person should have been doing more work. To avoid that confusion, spell out the members' duties, classes of membership, minimum amount of time required to be contributed by the members. That would be useful if applicable to your case. Will some members have the authority to act freely within their assigned areas of responsibility without the need to seek approval of other members, or some decisions will require unanimous approval or a majority approval of other members? Think about that. What ultimately happens if one of the members is not fulfilling their duties? Are members allowed to participate in outside competitive activities? How can new members be admitted? Will it be a member-managed company or manager-managed? What would it take to remove a manager? Indemnification. Do you want to disclaim member liability to the fullest extent allowed by state law or not? And of course, the procedures for indemnification. Would attorney fees be authorized, for example? The second big area is capital contributions. So you already know what you need for the initial capital contribution, but what happens if the company needs more money down the road? Will a unanimous vote of the members be required, or just a majority vote, or something in between? How will members be required to contribute additional capital in the form of sweat equity, for example? Will in-kind contributions be allowed, and how to value them? Keep in mind, by the way, that it is taxable income to receive a capital interest in exchange for services in an LLC if it's taxed as a partnership, which by default it is. So The higher you evaluate the sweat equity, the more tax liability you will incur. And one way to deal with it would be to contribute a nominal amount of cash initially to the LLC and then loan money to the LLC with interest by executing promissory notes with any or all of the members. And this way, everybody would retain their respective percentage ownership interest, and the LLC will be adequately funded without the extra tax burden. Profits and losses, will profits and losses be allocated on the basis of ownership percentages or some other basis? Remember, it doesn't have to be according to everybody's percentage ownership. Profits can be distributed based on milestones, based on different percentages of ownership or percentages of anything. You can distribute salary and dividends pretty much any way you want, but it does need to be spelled out in the bylaws or operating agreement to avoid disagreements and misunderstandings. When it comes to the meetings, when will the meetings be required? Is it okay to have a remote meeting over email, Skype, Zoom, and so forth? Who can call the meeting? Is there a quorum requirement, meaning a minimum number of, minimum percentage of interest must be present in a meeting for the meeting to even begin, for the decisions to be valid? So that's the quorum requirement, minimum percentage required to be present at a meeting. You also need to address what matters require voting by simple majority, what matters require supermajority, meaning more than 50%, let's say 3/4. What matters require unanimous consent, for example, big issues, dissolution, new capital. If it's two people in the company, you can be deadlocked, meaning one person 50% interest, and if you disagree, you can't move forward. How is the deadlock going to be resolved? Needs to be addressed. When it comes to transfer of interest, the main thing here is that company should have the right of first refusal before a member can sell the interest to third parties. Also answer the question, can the company purchase a member's interest upon their death? What happens upon their death? How will the event of protracted disability of a member be handled? Buyout provisions. In what circumstances members can force the other member to sell interest, and at what price? How will it be valued? When it comes to dissolutions, will any specific events be deemed liquidating events? What will be the priorities for distribution in case of dissolution? And when it comes to miscellaneous, useful boilerplate, of course, intellectual property, if anybody has to assign anything to the company, that must be spelled out, and you would probably need a separate attachment also for to list the intellectual property that is being assigned into the company. Governing law, example of useful boilerplate, the law of which state will apply to the contract. Tax classification, don't forget that. Is it an LLC taxed as a partnership? Is it a corporation taxed as an S corp? Whatever. Dispute resolution, whether you want the court resolution of disputes or arbitration. Can be remote arbitration, which is arbitration is like a private court, except it's cheaper, quicker, and confidential. But if you want it, then your contract needs to spell it out. Otherwise, by default, you would have to go to courts. So those are the main things that I wanted to bring to your attention. Those are the issues to think about when you're drafting that basic partnership document, whether it's a partnership or an LLC operating agreement, international joint venture, bylaws. Those are generally the things that you need to think about and to address in your main governing document. Let me know if you have more questions.